Can everybody hear me okay?
Yes, I can hear you.
Yes.
Judge Bertier, are you able to hear me?
I am.
Okay, it looks like council's ready to start.
Wonderful. Let's go ahead and begin then. We are here today for the in-custody arraignment calendar. Today is Saturday, March 28th. Are there any special requests regarding today's proceedings in terms of continuances or the order before we begin?
Not from the state, Your Honor.
I have one preference on order and one continuance.
Thank you. And what is the preference on order?
I would ask Mr. Parker be called last.
Thank you. And what is the preference for continuances?
I believe it's just going to be one for Mr. Cespedes. He is currently unwell and would like to be physically present for his bail hearing. He is unable to do so today. We would ask just a one-day continuance.
Thank you. So go ahead and we'll call that case for the record, and that is Ronix Cespedes. Is that correct?
That is correct.
Thank you. We are here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent the defendant. I will note the request for a continuance, and the court does find that there's sufficient good cause on the basis as discussed. Just to make sure that it's clear for the record, the public defender had indicated that the defendant is not able to be present today and wishes to be present. So we will go ahead and continue that matter until tomorrow at 9:30 a.m. Thank you. Next, we have Anthony Grames, followed by Clemencia Hunter.
For Mr. Grames, we would ask to waive his appearance and proceed with the hearing.
Thank you. We're here today for a first appearance, and this is on a fugitive matter, just for the record.
Yeah. Right there.
Good morning, sir.
How's it going?
I'm doing very well. How are you today?
Could be better, could be worse.
Thank you. We're here today for a first appearance. This is for a fugitive matter. The next step, just for the record, probable cause has been found, is the district attorney's office will be required to file a complaint. That will be due at the 72-hour hearing on April 3rd at 9:30 p.m. They are 9:30 a.m. They are required to provide that complaint by that date, or else you will be released, just to make sure that's clear. Thank you.
That's it? Yep. Thank you.
Clemencia Hunter.
Back to you. Thank you. All right. For Ms. Hunter, we would ask to waive her appearance and proceed with the bail hearing.
Thank you. We're only able to proceed on one matter, as it appears that the alternate public defender's office is not present. Madam Clerk, can you confirm that?
That is correct, Judge. No APD is logged on.
Thank you. So we are able to proceed, and we'll go ahead and, in that matter, which is the alternate public defender's office, we'll go ahead and continue this for one day until tomorrow at 9:30 a.m. And then with respect to the RPC case number ending in 66310, we will go ahead and proceed. I'll note for the record that the court, this is a first appearance bail hearing. Probable cause has been found. The public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates that she scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So in this case, we're asking for $5,000 bail, pretrial supervision, and testing. The defendant has lengthy criminal history going back to 2001, wherein she had a misdemeanor conviction for petty larceny in Sparks Municipal Court. Also had petty larceny conviction and possession of drug paraphernalia in 2002. Has a prior felony conviction for possession of a controlled substance in 2003. Her history goes on through the 2000s and up to recent. Again, as the court noted, she has that pending petty larceny and possession of drug paraphernalia case. She was ordered to supervision in that case back in 2025, had pretrial violations in July of 2025, had not followed through with the check-ins and alcohol and drug testing. She has similar facts on that case in that she similar facts. In fact, when she was arrested for the petty larceny, she had methamphetamine concealed on her person in that case as well, similar to this case. Also has failures to appear in 24, misdemeanor conviction for trespass in 24, has other felony convictions, including a 2018 possession of a stolen vehicle here in the second judicial, had a take vehicle without consent in the second judicial in 2018, other petty larceny and stolen property crime. So this defendant has continued her criminal conduct for about 25 years now, has failed at supervision in other cases here in this court, and therefore she's a risk not to appear, a risk to continue the conduct, and we'd ask that the bail and conditions and supervision be imposed. Thank you.
Thank you, defense.
Yes, we're seeking an OR release with appropriate pretrial release conditions. I believe random drug testing is fair and appropriate at this time. And then in the event that, well, I think maybe also adding a condition of required NA groups, perhaps 3 per week, would also be an added layer of protecting the community and ensuring future court appearances. The charge itself is simple possession. The amount as well is quite low. And I think that should be factored in terms of what type of release conditions we can employ and what type of danger or risk to the community she poses in herself. I do understand the state's receipt of prior difficulties on pretrial release conditions, but I do not see a record of adding mutual support groups and seeing failure thereafter. I wonder if we just take steps up from just traditional drug testing, maybe we'll get a different result, a different outcome. And speaking with Ms. Hunter, it's my understanding that she would be willing to attempt this going forward. And I would like to see that as an alternative to just straight incarceration going forward. But all the same, I will submit to the court.
Thank you. Based off of the information provided in the Nevada pretrial risk assessment, her conduct is outlined in her other case that is pending in Reno Justice Court, the court compliance concerns. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case and reviewing all the factors as outlined in NRS 178. Bail will be set in the amount of $5,000 that is bondable with a 10% cash option. If the defendant is able to post that bail amount, she will be required to be supervised by pretrial services and must check in within 24 hours of release. I am ordering the condition that she cannot possess any controlled substances or alcohol, including marijuana, unless she has a valid prescription and that has been approved. I will note that random drug testing is appropriate in this case, given the allegations as well as her criminal history. So that'll be the order of the court. I do find that there's a sufficient nexus. And we will go ahead and set that 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Nathaniel Stern.
In speaking with Mr. Stern, he was unable to be present today, but we would ask to waive his appearance and proceed with the bail hearing.
Thank you. Good morning. We're here today for a bail hearing. I'll just note for the record that this is a continued bail hearing. The defendant did score as a 13 or higher risk utilizing the tool. The court will go ahead and waive his appearance for today's proceeding. State, please proceed with your request.
Yes, Your Honor, we're asking for $5,000 bail on Mr. Stern. Defendant has criminal history going back to 2010. With a misdemeanor conviction for vandalism and trespass in that year. Much of his early criminal history is in California. More recently, he had a 2025 misdemeanor conviction for resisting a possession of drug paraphernalia in Sparks Justice Court. 2021 had 2 misdemeanor convictions for battery. 2021 also had a felony conviction for coercion with force. 2020 had obstructing, resisting conviction, also had a misdemeanor conviction for battery. And then prior to that, had issues with DUI in California, convictions, some other crimes in California. But again, an individual who has pretty consistent criminal history from 2010 forward. And so based upon that, he's a risk to continue this conduct. We'd ask that he that he have bail as well as testing, given his criminal history and his lack of compliance with law enforcement here. Thank you.
Thank you. Just for the record, what is the bail amount requested?
$5,000.
Thank you. And my apologies, I have too many screens. Can you confirm the allegation for the PC sheet?
Possession of a controlled substance and obstructing, resisting.
Thank you. Defense?
Yes, in terms of the state's burden to show the necessity for monetary bail, I believe they've met that burden. But in looking at Mr. Stern's background, I would ask for an OR alternative through direct transport to inpatient. It seems as though, obviously the underlying facts of the case involve drug possession, But in addition to that, you look at his criminal history, and I think it reflects somebody who just struggles with maintaining sobriety on his own. And I think with the right structure and the right one-to-one handoff that you can get through IAP transport to inpatient, we could potentially get a different result. So I would ask that be added as an alternative to monetary bail.
Defense, State, do you have any objection?
Your Honor, the only thing I would say is given his prior violence convictions, they're not domestic, but he's got the coercion with force and multiple battery convictions. I think that placement might be tough, but I don't have an objection if they're able to find something. I'm just not sure if that's defense probably knows better than I do about those requirements. But.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note for the record the likelihood of conviction as well as the court compliance concerns. With that in mind, bail will be set in the amount of $5,000 that will be bondable with a 10% cash option. This order will read bail or an own recognizance release through direct transport by IAP, DSU, or ASU to an appropriate treatment facility. And that is the least restrictive means that is necessary in order to ensure the safety of the community. If the defendant is able to post that bail amount, or if he is released through direct transport, he will be required to check in with pretrial services within 24 hours of release. And I am imposing the condition that he cannot use or have under his possession any controlled substances or alcohol or marijuana unless he has a valid prescription, be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus based off the allegations. Thank you. And we will set that 72-hour hearing, which we set for April 3rd at 9:30 a.m. Next, we have Lona Seguan, followed by Reina Vasquez.
All right. In speaking with Mr. Sugayan, she is not wanting to be present in court today. We would ask to waive her appearance and proceed with the bail hearing.
Thank you. Good morning. We're here today for a bail hearing, a continued bail hearing. The defendant did score as a 10 or a higher risk utilizing that tool. State, please proceed with your request.
Yes, Your Honor, we're asking for $10,000 bail, pretrial supervision and testing. The defendant, has criminal history going back to 2017. It appears that drugs have been an issue for her since then. She had a possession of drug paraphernalia conviction that year. Also in 2018, had a misdemeanor conviction for possession of drug paraphernalia and petty larceny. Also had a failure to appear arrest in that year. 2023, she had a possession of drug paraphernalia in Sparks Justice Court, a petty larceny conviction in municipal court, and a failure to appear arrest. She, concerningly here, had not only the fentanyl, which is obviously a concerning suspect, but or concerning substance. However, the provision of the sister's name, given that she was trying to hide from a warrant, I think also indicates whether or not she would be compliant, in addition to her failures to appear, which some of them go back beyond the 2 years, obviously, but indicates that she is likely to continue this use of controlled substance. And again, oftentimes you see theft crimes such as the petty larceny convictions that she has to support such habits. Also concerningly, frankly, is the fact that she was in a vehicle with someone who was apparently overdosing. So it shows the level of concern, one, for this controlled substance that she has, but also just the lifestyle and whether or not she would likely to commit crimes in the future or appear. So with all that taken into consideration, again, $10,000 bail, pretrial supervision with testing for alcohol and controlled substance. And I do believe that she has that hold out of Carson City from what I've reviewed. So obviously that would be essentially a risk not to appear in the future. If she's released here, she'd be transferred to Carson, I do believe. That I'd submit it.
Thank you, defense.
Yes, at this time, I'm seeking a lesser amount in bail, something more reflective of the current charges. I think $2,000 or $10,000 bondable is a bit steep for what is being alleged and what type of threat to the community she poses. While she did score a 10 on the MPRA, there were no points for prior felonies, violence, or failures to appear. I think by and large, it's just a concern about the flight risk. I think that necessitates monetary bail in itself. But as to the amount, I would seek the amount of $3,000 bondable. I believe that's more appropriate just given the facts and circumstances of the case. I would also ask for a 10% cash option because I am not certain what level of charges are being filed, but I do not anticipate a Category B felony. And I think what was alleged under these circumstances, if taken at face value, I believe that's Category C felony if you're providing another's identifying information to avoid prosecution. All the same, the amount of drugs found with Ms. Sugayan, fairly low when everything's taken into account. And I think her criminal history reflects somebody who's just in the deep throes of an addiction. This likely ends up in adult drug court or something similar. And I think we should set the bail amount with an eye towards that. So our formal request is that $3,000 bondable with a 10% cash option.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, as well as the factors as outlined in NRS 178, to include the likelihood of conviction, the allegations that contain the threat of harm to the community, but also the risk of non-appearance based off of the hold, as well as the court compliance concerns, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety, in order to ensure the appearance of the defendant. Bail will be set in the amount of $5,000. That'll be bondable with a 10% cash option. If the defendant is able to post that bail amount, she will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that she cannot use any controlled substances or alcohol unless she has a valid prescription and be subjected to random drug and alcohol testing. I do find that there is a sufficient nexus based off the allegations, and that will be the order of the court. We will set a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Reina Vasquez, followed by Brandon Hobbs.
Morning.
Good morning. We're here today for continued bail hearing. Defense, our state, are we ready to proceed?
Yes, Your Honor. So I would note that we were able to get in touch with the victim. And he says that he does not want a temporary protective order, that he has no safety concerns, that she has never done this before. What he indicated, they are separated, but they have been together for 20 years. He doesn't believe that she has substance abuse and no weapons. He indicates that he is okay with her coming back to the home, but this says they need to talk and reevaluate the situation. So the defendant, I show, has no prior criminal history, an NPRA score of 0. And so we have no objection to an OR. We would ask that she have pretrial supervision and a no weapons clause. And based upon the statements of the victim, we're not asking for no contact order. It sounds like they assist in taking care of a grandchild together. So I think in Obeah laws, obviously there's no other act of violence that would trip the Obeah laws. So just a supervision and no weapons in Obeah laws. Thank you.
Thank you. Defense?
We're seeking an OR at this time in conjunction with the NPRA score and I guess.
Do you have any objection? The state's asking for an OR, sir. Do you have any
No.
objection to the conditions?
No objection to the conditions. We'll submit with that.
Thank you. Ma'am, I am going to grant your own recognizance release here today. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. I will require that you be not supervised, but monitored by pretrial services. So you must check in with pretrial services within 24 hours of release. I do find that that is necessary in order to ensure the safety of the community. You are required at this time to not possess any firearms or weapons. And I'll just note for the record that that is due to the allegations that this is a crime of violence. That will be the order of the court, and you will be required to appear for an arraignment, which will be set for April 15th at 9 a.m. You are required to make all future court appearances, to obey all laws, and to comply with all these conditions, or else a bench warrant will be issued for your arrest. Do you understand?
I understand, Your Honor.
Thank you. We'll see you back here then.
Okay, thank you.
And then you're good to go back.
Thank you, Brandon Hobbs.
In speaking with Mr. Hobbs, we do have competency concerns, so we are asking for interim bail at this time.
Thank you. And just for the record, do you have any information as to whether or not he qualifies for the services of a public defender based off of the location? I believe that he might.
Yes, so besides that, his prior case was appointed to us, and he was recently released on that matter because it concluded. I spoke with him today. He reported no job, no place to stay, and no personal phone.
Thank you. I do find that he qualifies for the services of the Washoe County Public Defender's Office, so the Public Defender's Office will be appointed to represent him. I am in receipt of the Nevada Pretrial Risk Assessment, which indicates that he scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So, in this case, as far as the interim bail, we're asking for $3,000. I can, supervision would probably be appropriate, some sort of Reno Justice Court check-ins. And with that, I would submit it.
Thank you. The court will assess bail in the amount of $3,000 that will be bondable with a 10% cash option, and it will be interim bail. If the defendant is able to post that bail amount, I will require that he check in with Reno Justice Court within 24 hours of release. We will go ahead and set that 72-hour hearing, which we set for April 3rd at 9:30 a.m. Thank you. Next, we have Joseph Huddleston, followed by Nehemiah Johnson.
All right. It appears that Mr. Huddleston refused court today, so we would ask to waive his appearance and proceed.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada Pretrial Risk Assessment, which indicates that he scored as a 14 or a higher risk utilizing that tool. We will go ahead and waive his appearance for today's proceeding. State, are you ready to proceed?
Yes, Your Honor, we're asking for $5,000 bail. But obviously scores a pretty high score on the MPRA. Has criminal history going back to 2008. Had felony convictions in Oregon in that year for terroristic threats and domestic abuse. More recently, he had a misdemeanor conviction for possession of drug paraphernalia here in this court in 2025, as well as an arrest for failure to appear. 2024 had a misdemeanor conviction for fail to extinguish fire and possession of drug paraphernalia. Also had a misdemeanor conviction for possession of drug paraphernalia. A couple failure to appear arrests back in September and June of 24. Misdemeanor convictions for petty larceny, misdemeanor conviction for possession of drug paraphernalia. So the defendant has been engaging in similar type conduct recently, has had issues with failing to appear in the last couple of years, lengthy criminal history. Therefore, he's a risk to continue this conduct, risk not to appear. Of note as well is that obviously the prescription bottles were not in his name, which is concerning as to how he obtained those. And so taken, again, all in effect, he's a risk to the community. And we'd ask for $5,000 as well as pretrial supervision and testing. Thank you.
Thank you. And just for the record, would you have any objection to an unrecognizance release through direct transport to an appropriate treatment facility?
No objection to that, Your Honor.
Thank you. Defense?
We would be at this time submitting on monetary bail amount. I do believe the MPRA score plus his criminal history justifies some level of monetary bail. Now, I would advocate for the direct transport to inpatient with the appropriate diagnosis that we would get from a substance use evaluation. I think it's pretty clear from the factual allegations, but also his criminal history, that Mr. Huddleston is just struggling with abuse, and it's likely going to be resolved through structured treatment.
Thank you. The court does find that based on the facts presented, the Nevada pretrial risk assessment, as well as the factors in NRS 178, that bail is necessary in this case in order to ensure the appearance of the defendant and the safety of the community. Bail will be set in the amount of $5,000 just for the record. The court notes the failure to appear, the lack of ties, and the likelihood of conviction in setting that bail amount. This court will have the order read that it is bail or an OR through direct transport by IAP, DSU, or ASU to an appropriate treatment facility, and that is least restrictive means that can be imposed. If the defendant is able to post that bail amount or is transported, I will require that he be supervised by pretrial services and must check in within 24 hours release, and is subjected to random drug and alcohol testing and cannot use any controlled substances or alcohol unless he has a valid prescription. That is his. I'll just note that for the record, and I do find that there's sufficient nexus based off the allegations. That will be the order of the court, and we will set that 72-hour hearing for April 3rd at 9:30 a.m. Thank you.
And Judge,
Next-
I apologize. Can we confirm, is it 5,000 that you ordered?
Yes, 5,000 bondable with a 10% cash option.
Thank you.
Thank you. Next, we have Nehemiah Johnson, followed by Kevin Roman, or Kevil Roman. Good morning. My apologies with the Zoom. It just I could not see that anybody was there. We're here today for a first appearance bail hearing. Probable cause has been found, and the public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates the defendant scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, we're asking for $25,000 bond only bail. It's a Category B, understanding it's a weapon charge. We're asking for pretrial supervision, no alcohol or controlled substances possession, along with testing, as well as no weapons. So concerningly, the defendant has criminal history going back to 2002 with two felony convictions, one for possession of a controlled substance, one for possession of cocaine. 2003 had a gross misdemeanor conspiracy to commit larceny from a person conviction. Has criminal history through to recent. Concerningly, has a number of firearms arrests as well as other felonies. So 2007 had a felony conviction for grand larceny. 2008 had a felony conviction for attempted to commit unauthorized absence by a prisoner. 2014 had a misdemeanor conviction for battery, where he was also arrested for aiming a gun at a person in that case. Had a discharge of firearm into an occupied structure that was dismissed without prejudice in 2014. 2015 had a felony conviction for possession of a stolen motor vehicle here in the second. Had a 2018 felony conviction for misconduct involving weapons in Arizona. Had a drug conviction in 22 in Arizona. Had a felony arrest for a prohibited person possessing a firearm in California in 2024 with no disposition. Also had another felony arrest for a prohibited person possessing a firearm in California in 25 with no disposition. And recently had has his first history in Nevada in 2025 with a prohibited person possessing a firearm that was no issued here in the Reno Justice Court in 25. So very concerning, an individual who has been prohibited from having a firearm for over 20 years now, nearly 25. Having a firearm when he's contacted by law enforcement with a fairly sizable amount of drugs, with multiple firearm convictions and drug convictions previously. So this defendant's a risk to the community. Lack of ties to the community indicate he's a risk not to appear and take care of this case, and therefore we believe that the 25,000 pretrial supervision, testing, and no weapons are appropriate. Thank you.
Thank you. What's the information regarding the warrant? It indicated that he had a current warrant for, I believe, a misdemeanor.
I think that's so. I show in his criminal history that he has possession of drug paraphernalia case that appears to still be open. I apologize, I didn't check Reno Municipal Court. I can double check that. if the court would like, while defense is arguing, I apologize. I show the entry, but with no disposition, and I assume it's Reno Municipal Court, but I haven't double checked that.
Thank you. I appreciate that. I think that's sufficient, as I will just note I looked in Odyssey and did not find it there, so that would indicate that it's likely from that case. I appreciate that. Defense counsel, please proceed.
Yes, so at this time, we're seeking a lesser amount in bail. I believe $3,000 bondable with a 10% cash option would be appropriate. I understand that while he did score initially an 11 on the MPRA, that initial score also had no prior misdemeanors, no violence, and no failures to appear, though we do understand his criminal history involving drug abuse and weapon possession in the past. We were also able to reach out to a reference on his behalf. She was able to verify that he does have a local address he can return to if he gets out. She was also able to verify that he is self-employed, and he does have the ability to be regularly contacted. So that would mark his score from an 11 to either an 8 or a 7. That would put him as a high moderate. I'm seeking that to be reflected in his bail amount. And then turning to the factual allegations of the case, in reading it, I feel like this is just a matter of Mr. Johnson being in the throes of his addiction and then carrying a firearm for personal protection, just given the life that it leads to. When you are struggling with substance use on these streets, you need to be able to protect yourself, albeit it's not justified, and that's understood across the board. All the same, there was no indications of sales with Mr. Johnson. There was no allegations of violence. So it's not as though he is using this weapon against other people. Based on the facial allegations, it's looking like personal protection. All the same, I do believe a lesser amount of bail is more appropriate. I do think 3,000 bondable with a 10% cash option would be adequate at this time.
And sorry, Your
Thank
Honor, I did confirm that it was that possession of drug paraphernalia in Reno Municipal Court. That's the warrant. Sorry, thank you.
Thank you. I do appreciate that information. Based on the facts as presented, the Nevada pretrial risk assessment, and the factors as set forth in NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note for the record that the defendant is, based off of the information provided, a prohibited person, so that is extremely concerning to the court that a firearm is alleged in this offense. Based off of the lack of ties, the history of similar offenses, as well as the likelihood of conviction, bail will be set in the amount of $8,000 that is bondable, with no 10% cash option based off of the nature of the charge involving the firearm. If the defendant is able to post that bail amount, Mr. Johnson, you will be required to be supervised by pretrial services, and you must check in with pretrial services within 24 hours of release. I am imposing the condition that you cannot possess any firearms or weapons, as you are not permitted based off of your criminal history. Additionally, based off of the allegations, I do find that there's a sufficient nexus to require that you cannot use any controlled substances or alcohol unless you have a valid prescription and that's been approved. And you will be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus based off of the allegations. That will be the order of the court, and we will set that 72-hour hearing, and that will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Roman, Mr. Roman, followed by Stuart Stanley. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or a lower risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So I would note we've tried to make contact with victims. We were able to get in touch with the main victim, Amy. I'm sorry, Your Honor, I've got a number of individuals here.
And state, just as a reminder, if you are seeking a no contact order for any of those individuals, I will require that you state their names and spell their names for the record.
Yes, and sorry, I have that now. And I will be asking for no contact with this victim. It's Amy, Aimee, Ambriz, Ambriz. She indicates that she kind of knew the defendant as an acquaintance prior to this. She indicated that she didn't feel she needs a TPO. However, based on the facts here, we are asking for one. She says that she uh, doesn't want to appear here this morning, but would do so in the future. This with Mr. Roman is an extremely concerning case. Acknowledge that he has an MPRA score of 3 and no prior history. However, we are asking for bail in the amount of $40,000 bondable only, given the allegations in this case. Again, Miss Ambrose was shot in the stomach, very concerning for that risk. There was obviously, as set forth in the probable cause sheet, multiple other individuals who were also shot and sustained injuries during this incident. And so we would also ask for no contact with those victims. And I show those as Anahi, Anahi, Lopez Reymers, Lopez -Reymers, as well as Ivan Navarro, IvanNavarro, and then Celine Lopez Reymers, Selene, Reymers. This was an extremely concerning, violent case. Obviously, according to the probable cause sheet, there was a fight before this. Then the defendant fired multiple rounds, injuring multiple people. This is quite likely that there wasn't more serious injury to individuals. And frankly, given the defendant's admission that he was the one that fired these shots, it's an extremely provable case. So concerning, frankly, for the fact that there's gang involvement alleged here, I would ask that there be a no contact with validated LMT gang members, based upon the allegations in the probable cause sheet that this was a firearm that was used by other LMT gang members. Again, with the fight, this appears to be adjacent to gang lifestyle. And so we believe that one, a high bail, even though the defendant scores a 3, I think $40,000 takes into consideration that low score on the MPRA, given the violence and risk to the community here, especially for a defendant who is 18 years of age, as well as the no weapons and no contact with these individuals. And with that, I would submit it.
Thank you. Defense?
Yes, at this time, we're seeking the lesser amount in bail. I believe $5,000 bondable is appropriate at this time, just given Mr. Roman's scoring on the MPRA and everything that's being accounted for through that MPRA, right? So while he scored a 3 on the MPRA, those are points for age of arrest, for the fact of him being 18 years old, and then unable to verify his phone line, but he does represent that he, in fact, has a phone. The reason why we're seeking a lesser amount in bail is ordinarily this would have been an OR release, but given the severity of the charge, that kind of puts us in the realm of monetary bail being required, especially in light of provability of the case. I just see that we don't have any record of him being unsupervisable. We don't know if there's any pretrial release conditions that have been failed by Mr. Roman that could potentially protect the community and ensure future court appearances. We just don't have a track record. I'd like to see some type of track record with Mr. Roman. And in order to potentially see that type of execution with Mr. Roman, we need an appropriate bail amount set. Given his MPRA score, given his age, given the absence of failure to comply with court orders, I would ask that bail be a lesser amount and that $5,000 bondable, and then defense will submit with that.
Thank you. Based off of the information provided, the Nevada pretrial risk assessment, as well as the factors that's set forth in NRS 178, the court does find that a detention order is appropriate in this case. The court does find that there are no least restrictive means that can be imposed in order to ensure the safety of the community. I will note, just for the record, the significant threat of harm to the community and the named victims in this case, as outlined in the probable cause sheet. The court does consider the Mr. Roman to be presumed innocent of all charges. I will note the likelihood of conviction as set forth, and again, the significant danger as discussed and presented with those individuals. With that in mind, the court is finding that bail is appropriate, and bail will be set in that amount of $40,000 bondable with no 10% cash option based off of the nature of the charges. If the defendant is able to be to post that bail amount, he will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that he cannot possess any firearms or weapons, as this is an alleged crime of violence. I'm also imposing the request that he's to have no contact with validated LMT gang members if he is released on this case. So just to make sure that is clear, he must stay 100 feet away from all individuals and have no contact with any individual who is a validated LMT gang member. I will also impose the no contact order with the named victims in this case. And just for the record, that does begin immediately. So, sir, you are to have no contact with the named victims in any way, shape, or form through social media, text, email, electronic means, either directly or indirectly. That means someone working on your behalf. And again, that begins immediately, and you must stay 100 feet away from them. And that is those individuals that the state had discussed of Amy and Bees, Anahi Lopez, Ramers, Ivan Navarro, and Celine Lopez Ramers. That will be the order of the court. And we will go ahead and set, I believe that I said it, but just in case I did not, I am imposing a condition of no firearms or weapons, as this is alleged crime of violence. And the court will set the 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Stuart Stanley, followed by Arthur Sedeth. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, sir. So in this case, we are asking for $100,000 bail. The defendant, in pretrial supervision, as well as testing for alcohol and controlled substances, and stay in northern Nevada. The defendant has lengthy criminal history going back to the 80s. His first arrest I show was in 1983, possession of a controlled substance case where he had a deferred disposition in Kitsap, Washington. Had a first felony conviction for controlled substances, for deliberate controlled substances in Port Orchard, Washington in 1987. Has a lengthy criminal history, fairly continuous from that time. Most recently has a felony arrest for possession of controlled substance for sale with no disposition in Riverside, California from 2025. Has many convictions in Indio, California. That appears to be his primary base. 2023 had 2 misdemeanor convictions for possession of controlled substance in Indio. 2022 had 3 misdemeanor convictions for possession of a controlled substance in Indio. 2018 had a felony conviction for assault with a deadly weapon in Indio. 2013 had a felony conviction for PCS for sale in Indio, and had a case that was initially a felony conviction for possession of a controlled substance, but was later reduced to a misdemeanor in Indio. His only ties with Nevada appear to be a 2012 forgery arrest where he was ultimately dismissed. He had a conviction for domestic battery in Las Vegas in 2003. It appears that was a case that was pending for a number of years before he ultimately resolved that case in Las Vegas. 2010 felony conviction for possession of controlled substance in Indio. 2007 possession of a controlled substance felony conviction in Riverside. Also felony conviction for possession of controlled substance in Banning, California. Had a couple one grand theft and a take vehicle without consent felony conviction. Those were both in Indio in 2003. Again, history goes on. Similar type offenses, drugs and taking vehicles. Through the 90s, he has arrests and convictions in Washington, Oregon, and California, and then the Nevada history that I referenced. And what is concerning, again, as a probable cause sheet indicates, tens of thousands of dollars worth of drugs in his possession, indicates 53,000 over 53,000 lethal doses of fentanyl, with the fentanyl that he tossed over the railing. So obviously concerning that he had done that for the risk of the public, anyone walking on the street below, where he had tossed that, essentially tossed it into the wind for any individual who was walking down below to be at risk. So this is an extremely concerning defendant, had thousands of dollars in his pocket on his person that appears to be related to this. They observed what they believe to be a hand-to-hand sale with this defendant. So extremely concerning defendant with no ties to the community other than his poisoning this community with fentanyl. And so he's a risk to the community, risk not to appear. And we believe that a high bail with those conditions is appropriate. Thank you.
Thank you. Defense?
Yes, we'd ask a lesser amount on bail at the amount of 10,000 bondable with no 10% cash option. And speaking with Mr. Stanley, he has no monetary means to post any amount of bail. So what the court strives to achieve with setting monetary bail will be achieved with $10,000 bondable as compared to setting it with $100,000 bondable as requested by the state. While Mr. Stanley scored an 11 on the MPRA, he had no points for prior failures to appear. And we were able to speak with a reference who was able to verify that he currently receives Social Security. He does live full-time in California, but can return to Reno to address court matters as they come up. And up to this point in time, he did have a phone, albeit it has now been seized by law enforcement. So otherwise, he would have been contactable and probably still could be if afforded an opportunity at any type of pretrial release. Again, because he has no means to post any amount of monetary bail, I do believe what the state is seeking in terms of protecting the community and maintaining attendance at all court appearances can be achieved with $10,000 bondable as compared to what they previously suggested. So with that, defense will submit.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. I will note the higher Nevada pretrial risk assessment, the lack of ties to this community, the threat and harm to the community, the lengthy prior history of similar offenses, and the likelihood of conviction. The court will note in the factors that has not been presented significant amount of information regarding the defendant's financial means. I will note the significant amount of controlled substances and of different controlled substances, as well as I will note that he is on Social Security and did qualify for the public defender's office in reviewing all the factors. And so with that in mind, the court will set bail in the amount of $60,000 that will be bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that he cannot possess any firearms or weapons unless he has just no firearms or weapons based off of his criminal history, as well as due to the allegations in this case. State, I do not recall hearing a request for testing, and I'm not inclined to grant. I just want to confirm.
I did ask for testing for alcohol and drugs.
Okay.
Yeah.
Just based off of the charges, is it?
Well, and his criminal history again, it's pretty consistent that he's got a lot of it recently. I think with the changes in California law are misdemeanors, but he has many felonies going back to the 80s and has received diversion. That's his primary criminal history. He has some violence, but many convictions for drugs.
The court did not recall hearing a recent conviction for a drug possession.
He has an arrest for possession for sale with no disposition in 25, and then two possession of controlled substances in 23, and 3 in 22 is what I show.
The court will note that that's not, I have some concerns regarding the nexus. However, given the allegations with the specific several different types of amounts, and there is that criminal history, the court will impose testing. So I do find that there's a sufficient nexus, and I will require that the defendant cannot use any controlled substances or alcohol, including marijuana, unless he has a valid prescription, and be subjected to random drug and alcohol testing. That will be the order of the court. I'm not imposing the other request, and we will go ahead and set that 72-hour hearing of April 3rd at 9:30 a.m. Thank you. Next, we have Arthur Sudduth, followed by Giovanni Chaparro.
I spoke with Mr. Sudduth today. I would ask to waive his appearance and proceed with the bail hearing in his absence.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 15 or a higher risk utilizing that tool. We will go ahead and waive his appearance for today's proceeding. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Mr. Sudduth, we're asking for $5,000 pretrial services, testing for alcohol and drugs, no contact with any Home Depot in Washoe County. The defendant has again a higher score at 15. Criminal history going back to 2019, an arrest in Alaska. It looks like there was no ultimate charges filed. More recently here, starting in 2023, he had a couple of failure to appear misdemeanor convictions in Sparks Municipal Court. Also had a misdemeanor conviction for camping in public in Reno Municipal Court, where he failed to appear. 2024, gross misdemeanor conviction for battery on a protected person here in the second. He absconded from Vitality. In that case, he had a misdemeanor conviction for possession of drug paraphernalia in Reno Justice Court. Had a trespass upon railroad tracks in Reno Municipal Court, where he failed to appear. 2025, he had failure to appear arrest, possession of drug paraphernalia conviction here, misdemeanor conviction for possession of drug paraphernalia in Reno Municipal Court, failure to appear arrest, misdemeanor conviction for failure to appear in Reno Municipal Court, misdemeanor conviction for disorderly conduct in Reno Municipal Court, and then a misdemeanor conviction for possession of drug paraphernalia in Reno Municipal Court. So again, over the last approximately 3 years, many failures to appear, many issues with controlled substances and that adjacent lifestyle. And so we would ask for, again, those conditions of 5,000 pretrial services, testing for alcohol and drugs, and no contact with any Home Depot in Washoe County. Thank you.
Thank you. Defense?
Yes, I'd ask for a lesser amount in bail to the tune of $500 bondable with a 10% cash option, just given the nature of the charges. While he did score a 15 on the MPRA, I think by and large, his criminal history just reflects an individual who is struggling with substance use issues and is committing petty offenses across the board. I think by and large, the solution is through treatment. And then when you turn to the factual allegations, the amount stolen is quite low. I think it was close to like $129. Personal use amount found on his person, about 1 gram of meth. I think that's more fitting of a far lesser amount in bail, but I do understand the necessity for bail to be set in this case. So with that, defense will submit.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community and the appearance of the defendant. Bail will be set in the amount of $5,000 bondable with a 10% cash option. I will just note for the record that it's due to the court compliance concerns, the failure to appear, the lack of ties to this community, and the likelihood of conviction. The court will impose the following conditions: that if the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that he's to have no contact with any Home Depots in Washoe County, as well as be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus to require that he cannot possess, have under his custody or control any alcohol or controlled substances without a valid prescription. That will be the order of the court, and we will set a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Giovanni Chaparro, followed by Eileen Drensky. Good morning. We're here today for a first appearance at bail hearing. Probable cause has been found and the public defender's office has not been appointed to represent you yet. Sir, did you have you hired an attorney to represent you?
No.
Thank you. Do you wish for me to determine whether or not you qualify for the services of the public defender?
Yes, please.
Thank you. So, sir, assuming you are to remain in custody, are you able to still receive an income?
No.
Thank you. I do find that you qualify for the services of public defenders. The Washoe County Public Defender's Office will be appointed to represent you. State, what is your request here today?
Your Honor, in this case, we're asking for $500 cash bail as well as no driving unless properly licensed. What's concerning about Mr. Chaparro, so he had a misdemeanor conviction for DUI in 2024 that I think was what ultimately caused his license to be revoked. He was outside the revocation period when he picked up a citation that resulted in a misdemeanor conviction in 2025 for driving while revoked. He just had a misdemeanor conviction where he pled on March 5th to a driving revoked. So he's now looking at his third driving revoked. He's just not getting the message, and is therefore a risk to the public. With the stacking of these revocations, he's essentially going to never get his license back if he doesn't change his ways. But given the understanding it's a citation or an arrest for driving revoked, at the same time, he was just here and has had now his third. So with that, I would submit it.
Thank you, defense.
Yes, I'm seeking OR release for Mr. Chaparro at this time. Very light criminal history. This is a driving offense that could have ultimately been a citation had it been not successive. And I think appropriate release conditions can quell any further harm to the community. I think essential ones would just be check-ins with pretrial services, and then no driving clause without appropriate documentation. Certainly, Mr. Chaparro has the message received at this time that he cannot be driving without an appropriate driver's license on the books, and he understands that he's not going to be able to have that if he keeps doing things like this. I don't think continued incarceration is justified with this type of charge and with this criminal history. I also don't believe the state has carried its burden of proof for necessitating bail today.
Thank you. I'll just note for the record, the court is extremely concerned regarding his criminal history involving continuing to drive while he has a revoked driver's license. Pursuant to the NPRA and the factors as outlined in NRS 178, the court is going to give the defendant this one opportunity. So, sir, I just want to make sure it's very clear for you. If you are found driving without a valid driver's license, it is very likely that you will be required to be remanded into custody and stay there until this case is concluded. Do you understand that?
Yes, Your Honor.
Thank you. So with that in mind, I am granting an unrecognizance release. I will require the defendant to check in with Reno Justice Court within 24 hours of release. So that will be on Monday. You are required to not drive, and I'm going to include this as specifically in this case of no driving without valid documentation, and that is due to community safety. We will set your arraignment, which will be set for April 15th at 9 a.m. And you must make all court appearances, comply with these conditions, and obey all laws, or else a bench warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Thank you. We'll see you back here in court on that date and time.
Okay, so let's go to the
Eileen Drensky, followed by Juan Mena. Good morning. We're here today for first appearance bail hearing. Probable cause has been found, and the public defender's office has not yet been appointed to represent you, as you indicated that you would retain private counsel. Have you hired an attorney to represent you?
No, but I will during this week, and I do not qualify for a public defender.
Okay, so I'm going to ask you a few questions. So what we can do is continue your hearing to see if you qualify for the to hire that private. Let me just finish this, okay? No problem. So I can continue your bail hearing, which means that you would stay in custody until you've hired an attorney to give you that opportunity to have your attorney represent you, or I can determine if you qualify for the purposes of the public defender for the bail hearing.
I would prefer the public defender for
Okay.
the bail
So I'm
hearing.
going to have you listen to my question very carefully, okay? If you are to remain in custody, are you able to make any money?
Yes,
How are you able to make money?
I receive pensions from the state.
Okay.
And,
Will you receive that pension if you are in custody?
yes,
Okay. And what is that amount?
as far as I know. Close to $4,000 a month.
Okay, I will go ahead and appoint the public defender's office for the purpose of bail, and this will be readdressed at your next hearing. Just for the record, the court is in receipt of the Nevada pretrial risk assessment, which indicates the defendant scored as a 4 or a low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So at the outset, I would acknowledge that Ms. Drensky has no prior arrests that I can find, has the NPRA score of 4. Frankly, what's concerning about this case, put in the notes, no good deed goes unpunished. Ms. Drensky was driving and unfit to be driving, as noted by the officer, essentially admitted to taking twice as much of her medication as she should have, and rather than conducting rather than being arrested for DUI, she was given the benefit of having her son-in-law come pick her up, and she responded to the officer by slapping him. So very concerning. However, I do acknowledge that she has no prior criminal history, scores an NPRA of 4, so I'm not going to object to an OR release. Concerning, given the prescription, I would ask that she have a condition of no drinking or controlled substances that's not prescribed. Understanding that alprazolam is realistically prescribed given the facts and circumstances in this case, and that an order such as take it as prescribed would probably be difficult to comply with. I think that no alcohol is appropriate given alprazolam and its effects with alcohol. Understanding there's not alcohol alleged here. However, it's a concerning situation that frankly didn't need to happen at any level. There should have just been a ride home and proper taking of medication. But we would ask for pretrial supervision throughout the process. And with that, I would submit it, Your Honor.
Thank you. Defense?
Yes, we're seeking that OR release. Now, with the conditions for said OR release, I believe it's just more appropriate for pretrial services check-ins. I don't think alcohol testing is appropriate given the allegations of the case and also Ms. Drensky's complete absence of criminal history. In addition to that, I don't know if drug testing actually curtails any issues raised by this case. I don't believe that pretrial services nor Aver Health have the ability to test appropriate levels for this type of substance in her body in conjunction with what are the appropriate ways in which she is supposed to be taking the prescription. So this requirement of take prescription as prescribed, but we're going to monitor it through drug testing, I'm not sure actually is cohesive with that type of
Thank you,
supervision.
State. I don't recall hearing a request for testing.
I just asked that there be no alcohol, and I concur that I don't know a way that we could test for the alprazolam. I guess more of a admonishment that she needs to take it as prescribed, not as she apparently admitted that she doubled the dose. And that I understand there's not much we can do on that, but it's just concerning given the facts. Maybe more of an admonishment from the state, I guess, than a request for a condition.
Nico, I just want to make sure that I understood that correctly. So please proceed, defense.
Yes, then with that clarification and admonishment is sufficient, and then we will submit with that.
Thank you. I'll just note for the record that the court is not aware of, in terms of what Aver Health is able to do for the testing. If this was with DAS, I'll just note that the court did have that information regarding the levels. And so it was possible. I just don't have that information. So I'll just note that for the record, that the court does not have sufficient information as to find just with respect of that. However, the court does find that the release restrictive means that can be imposed. So ma'am, you will be released here today. I am requiring that you be monitored by pretrial services. So what that means is you must check in with pretrial services within 1 business day of release. So that'll be this Monday. You are required to take all medication as prescribed. I am ordering that. And you are required to, and that is due to community safety. I am imposing the condition that you cannot use any controlled substances or alcohol without a valid prescription. Just to make sure that is clear, is if you are taking 2 of those pills per day and you've only been prescribed 1 per day, that is a violation. So just to make sure that is very clear for you. You will be required to appear for your arraignment on April 15th at 9 a.m. So you must appear in Reno Justice Court on that date and time, make all future court appearances, obey all laws, or else a bench warrant will be issued for your arrest and comply with these conditions. Do you understand?
Yes, ma'am.
Thank you.
Thank you.
So. Ordered on Monday.
Juan Mena, followed by Gerald Jones.
Okay.
In speaking with Mr. Mena, we would ask to waive his appearance and proceed with the bail hearing.
Thank you. Good morning. We are here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 13 or high risk utilizing that tool. State, are you ready to proceed?
Yes, Your Honor. So in this case, we're asking for $5,000 bail, no contact with 2695 Carville Drive, number 204, as well as no contact with Alfina Guerrero, the vehicle owner in this case. The defendant's criminal history is concerning for the number of arrests and convictions, as well as his lack of compliance. So it started in 2015, where he had a felony conviction for possession of a short barrel rifle or shotgun. He was disorderly discharged from parole in that case. Had 2 misdemeanor convictions for resisting, as well as a misdemeanor conviction for domestic battery in 2015, where he had a failure to comply bench warrant. 2018 had misdemeanor conviction for battery, felony conviction for assault with a deadly weapon. He failed to appear at pre-sentence, had parole violation arrest. Also had a misdemeanor conviction for domestic battery second in 2018, where his bail was revoked. 2021 had a misdemeanor conviction for ex-felon failure to register, as well as possession of drug paraphernalia. 2023 had a felony conviction for attempted Resberg. He also had a battery by a prisoner in that case that was dismissed as part of the negotiations for the plea to the underlying felony. Also had a failure to appear arrest in that year. 2024, a misdemeanor conviction for resisting, misdemeanor conviction for possession of drug paraphernalia, another misdemeanor conviction for resisting, had a stalking charge that was dismissed due to the plea there. Misdemeanor conviction for domestic battery in 2025, as well as trespass. Misdemeanor conviction for battery that was reduced from a battery by a prisoner. Misdemeanor conviction for stalking and TPO violation in Reno Justice Court. Misdemeanor conviction for failure to register in Reno Municipal Court. Misdemeanor conviction for trespass, Reno Municipal Court. Misdemeanor conviction for battery ×2. Another misdemeanor conviction for domestic battery second. And then in 2026, we have misdemeanor convictions for disturbing the peace and resisting and possession of drug paraphernalia, as well as trespass. So the defendant's criminal history speaks for itself somewhat. At least 22 misdemeanor convictions and 3 felony convictions. Multiple domestic batteries, crimes of violence, failing to comply with court orders. So again, even on essentially this misdemeanor level charge, $5,000 is appropriate with the no contact, and we'd also ask for no weapons given the prior violence and the domestic ramifications here.
Thank you. Just to confirm, as you indicated, misdemeanor, it's the court's understand. Are you indicating that this would be pursued as a misdemeanor? I believe that the charge was for the gross misdemeanor.
So I think it's likely to be charged as a misdemeanor. It is a gross misdemeanor level, I believe, given the I think a pretty reliable estimate from an individual who works in the field, but I think it's probably likely to be charged as a misdemeanor.
Thank you. Defense?
Yes, I would ask for a lesser amount of bail in the amount of $3,000 bondable with a 10% cash option. Understanding his score on the MPRA and his criminal history, bail is necessary to maintain protection of the community and attendance at future court appearances. I do believe just the depth of destroyed property in the underlying facts of this case would warrant more so $3,000 bondable as compared to the suggested $5,000.
Thank you. The court does find that based off of the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178, that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. Bail will be set in the amount of $5,000 that will be bondable with a 10% cash option. I will note that at this time, I am requiring that the defendant be supervised by pretrial services. If the defendant is ultimately charged with a misdemeanor, I will just note that he shall be removed from pretrial services and that it shall be Reno Justice he must check in with Reno Justice Court. I am imposing the condition that he's to have no contact and that begins immediately with Alfina Guerrero, as well as the location of 2695 Carville Drive, number 204. I do find that there's a sufficient nexus in order to ensure the safety of the community, and to just make sure that is clear, that begins immediately. I'm also imposing the condition that he cannot possess any firearms or weapons, as this is a crime of violence. I will just note for the record that part of the basis for that amount is due to compliance concerns, the history of violence, and lack of ties. That will be the order of the court, and we will set a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Gerald Jones.
Yes, I spoke with Mr. Jones this morning. I do have competency concerns, so I am asking interim bail at this time.
Thank you. I'll just note for the record that this court did grant an own recognizance release. Additionally, there is no public defender assigned to this case yet. Do you have information as to whether or not the defendant qualifies for a public defender?
In my contact with him, he more or less refused to answer any of my questions.
Thank you. I will note then, in the interest of justice, the court will appoint the Washoe County Public Defender's Office to represent the defendant, as well as based off of the information regarding the concerns as outlined. So the Washoe County Public Defender's Office will be appointed to represent the defendant. And just to be clear, you are requesting still for an interim bail rather than the OR to remain?
No, I'm not requesting that.
Okay. Thank you. State, if that is the inclination, the court's already made its ruling, it's not quite appropriate to come back at this time. So I'll just note that if he is not being held on this matter, so if he is able to, I don't have the information, so I don't know, defense, if you're able to just, I'm sure that you did already, but just note that he is granted that release. As long as he signs that paperwork, he's more than welcome to be out on his own recognizance. What we will do is, Madam Clerk, let's just go ahead and set a 72-hour hearing in case he is still in custody, and we can modify that to the arraignment date if needed. And so that is April 3rd at 9:30 a.m. Thank you. DeAndre Parker.
Spoke with Mr. Parker today. We would ask to waive his appearance and proceed with the bail hearing.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent Mr. Parker. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So in this case, we are asking for $100,000 bondable only bail, given the nature of these charges. This defendant, while scoring an 8, has a
Judge, may I just interject briefly?
Yes.
Given the state's suggested bail amount, we are going to submit on that request.
Thank you. I appreciate that. State, please proceed.
Yes, Your Honor. So in addition to the $100,000 bond only, we are asking for pretrial supervision, house arrest, GPS house arrest, no contact with any minors, including daycares, schools, and no weapons given the prior felony convictions of the defendant.
Thank you. Based off the information provided, the Nevada pretrial risk assessment and the factors as outlined in NRS 178, the court will set bail in the amount of $100,000 that will be bondable with no 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services, which that will be required to be within he must check in within 24 hours of release. I am imposing the condition that he cannot, or that he will be subjected to GPS monitoring and subjected to residential confinement. It is the court's belief that I may have required that in his separate case to be with, at the Washoe County Jail. So just make sure that's clear that is before release. I did not hear that request from the state, but I do find that that is appropriate given the allegations. And so that is the requirement that it will be prior to release. I am imposing a no contact order with, so just make sure it's very clear, if he's to have no contact, I must stay 100 feet away from any minor children. Just to make sure it's clear, I'm sorry, it'll be a no unsupervised contact with any minor children, and it must stay 100. State, my apologies. I am inclined to include at the feet. However, if I do 100 feet, that is, he's not able to go to the grocery store. So is it sufficient to just say no unsupervised contact with minor children?
Yes, I think we could craft 100 feet away from any school or daycare. With the GPS house arrest, I think that should be able to be determined if he's close to a school or something of that nature, and that would, I think that would suffice.
Thank you. I'll note that for the record, the court will grant that request. And that will be subject to then the monitoring to ensure that. And I'll just note that I don't know where he resides. So if he's able to be posted bail amount of that be taken into consideration that he's allowed to return to his property. That will be the order of the court. And we will set a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. I believe that is the last one from today. Just want to confirm. I appreciate everyone's time here today. We had some issues this morning, so I do appreciate everyone being prepared and ready.
Of course.
Yeah, I think that's everyone. Thank you, Your Honor.
Thank you. Have a great day.
You too.